Impact of influence.
Covering true crime throughout the Southeast.
Coming up in this episode, what these headlines are about: a perfect storm of investigative incompetence, an investigative failure, and fabricated evidence. Hello, friend, Matt Harris and Seton Tucker. Always grateful that you get to join us, and they can join in the conversation.
You can find us on Facebook at Impact of Influence and also on our YouTube channel.
When you get to the YouTube channel, hit subscribe. That's very important. It helps us out a lot. And we are part of the Evergreen Podcast Company. Support our sponsors like Quince, for instance. So today we're going to be talking about Alec Murdaugh.
Yes.
And this big stack of paper you got here.
Initial reply brief of the appellant, which was filed on September 9th of 2025.
Yes, by his attorneys, Dick Harpootlian, Jim Griffin, Philip Barber, Maggie Fox, Alec. I don't know if you're listening to this, you probably know this, of course, but he is serving 2 life sentences for the murders of Paul and Maggie Murdaugh, his wife and son. And so the defense presented something to the court, and then the prosecution did, and then now the final stage.
Yes. So in this response, let's go back to the state's response that they were applying to. They talk about this amount of overwhelming amount of evidence pointing to guilt of Alec Murdaugh in their brief. And in the appellate brief, the Murdaugh team points out investigative failures and fabricated evidence.
That's right. And there's a long list that they bring up in this. So we'll bring in our professor here in a second to talk about it. They say, as in Murdaugh's people, the evidence actually shows a contaminated crime scene with ignored alternative suspect evidence, fabricated blood spatter testimony the state abandoned when exposed, cell phone evidence that supports Murdaugh's innocence, no credible motive for such extreme action, critical forensic evidence lost through investigative malpractice, pretty harsh word. Among other things, the brief points out things like the unknown DNA under Maggie's fingernails was not sent to CODIS for comparison, and the failure to collect fingerprints from the feed room doors and doorknobs. So those are just some of the things when it comes to the evidence, and we'll talk more about that in a second.
Well, let's bring on my dad.
Yep. Matt Siembieda is here, graduate at the University of Penn Law School, and has practiced for many years and is a Temple Law School professor. Hello, Professor Matt.
Hey, how you doing? Thanks for having me on.
Well, thanks for being here. Got some questions.
Okay, so let's get into some of the nuts and bolts of what the appellant's response was. They're talking about the state had said that there was this overwhelming amount of evidence which pointed to guilt, and they say, hey, wait a second, this is not exactly what we see the evidence saying. My question to you is, can you retry the cases in these briefs presented by, both of them are kind of, saying the statement of facts. Can you retry it at this juncture?
Well, generally, what happens on appeal, particularly in criminal cases, is that you're trying to raise a number of issues with the hope that one or more of the appellate judges grasp onto it and decide that that's important for them to reverse. So that's the strategy that's involved. Now, in terms of this particular case, the best argument seems to be the jury tampering case. And I know the state spent a lot of time, and so did Justice Toal when she had her hearing about the overwhelming evidence pointing towards the guilt of conviction. However, there's no overwhelming exception to jury tampering. There's no case that says that. So that if there is a jury tampering, there's supposed to be a presumption that he's entitled to a new trial. Now, it doesn't go to whether or not he's guilty or innocent. What it goes to is the fairness of the process. Now, I understand from filing the case and being involved with you guys for a while and listening to your various podcasts that the evidence seemed to be fairly strong in a lot of ways that he was guilty. But that is really irrelevant as to whether or not he got a fair trial. And if you have somebody like the clerk of court tampering with the jury and influencing what they do, the idea is that it's awful tough to put the genie back in the bottle. that once that happens, it's tough to recreate what it would have been like if it didn't happen. And that's why courts tend to give people new trials on those issues. Now, the other evidence that's there is evidence, as I said, throwing up against the wall to see if one of the justices grasp onto it. Now, maybe a justice may think, for example, that the way they conducted the grand jury with the blood spattered shirt that didn't exist is reversible error on itself. Maybe someone might decide that there was a lot of other exculpatory evidence there that he wasn't the one who did it because of the fact that there were phone issues, cell phone issues, and other issues around that, and the lack of direct evidence of him committing the murder, such as the failure to find a weapon, the failure to find any of his DNA on their bodies, the failure to find any blood on him in any way, and stuff like that. Now, my view is just very straightforward that it's very easy for an appellate court, and generally they will say that that was in the discretion of the judge, that that was harmless error. You had the ability to raise that during the course of the trial, which you did in many, many instances, and the jury could weigh all that there. So the real issue is the jury tampering issue, in my view.
Well, let me ask you this one question though. So this evidence that was presented to the grand jury, the blood splatter shirt, which didn't really exist, and then we had some evidence presented about guns found in the home, which had this bird shot, buckshot combo, which was what was found to be used in the gun that was not recovered, but that Paul used to murder Paul. Um, what if wrong information was presented to a grand jury? Does that matter at all?
Well, the question is was it persuasive or was it harmless? What this case most likely turned on was the fact, other than maybe possibly jury tampering, what this case probably turned on was that cell phone video that popped up on Paul's phone sometime after the indictment. And that cell phone video basically showed Alex at the scene shortly before or at the time that they were killed. And that seemed to be the overwhelming evidence that existed of conviction. Now, does he have the ability to refute that? Does he have the ability to do other things? Yes. And that's why he's probably entitled to a new trial to do that.
I have a question about this overwhelming evidence. They both did the evidence thing, and they're smart enough to know that that's really not what we're arguing here. We're arguing mainly over, as you said, the jury tampering and which way we're going to rule on that. Are they both letting out information in case there is a retrial? They're kind of planting seeds in a potential juror's mind with some of the things that they're saying on here. Is that a possibility?
I don't think so. I mean, I think a trial, if it happens, is probably a distance away. That information was heard and seen, during the first trial and was available. So I don't think what's taking a part in the appellate's court is done in any way to, influence or not influence a jury panel going forward.
And when
And we
you,
didn't see the evidence that was presented to the incorrect evidence that was presented to the grand jury. That was not
yeah,
presented during the trial, and he was still found guilty.
but I'm just talking about some of the things that they talk about, the evidence collected, the
Right.
forensic evidence, the cell phone, all this stuff. And a lot of things I looked at this and I'm like, well, why didn't the defense make a bigger deal of some of these things at the time? It's almost like they're pointing out, well, we should have done this, should have done this, should I don't know the law, but it seems to me like some of these things could have been challenged more. Am I wrong in thinking that?
No, you're correct. I think that they were thrown off balance by two things early on. One was the fact that the judge let him get into all the financial information, so there were 6 days or more of that. And the second, maybe more important, it was that cell phone recording of Paul of Alex at the scene where he had basically denied it to the police initially. So I think those were the things that threw them off. Do I think that they should have made more of this evidence? Yeah, but I understand in the heat of a trial while you're trying to deal
Yeah.
with all these moving parts and stuff.
Well,
Monday morning quarterbacking is a lot easier, right? Yeah.
some of
Right.
this stuff was really last minute. Like the cell phone data, like some of this came in actually while the trial was happening.
True. And they did bring up some of the things like the Shire marks and the DNA, but I they talk about not or a single focus of the investigators. But just correct me if I'm wrong, Seaton, it didn't seem like they presented any other options either as the defense. At least not it didn't seem like they were other than the height of the shooter.
Well, and we didn't hear from Eddie. And remember, there was that evidence we heard when we interviewed Jen Wood a few weeks back, and she said, she discovered some communications that occurred with between Alec and Eddie, but the defense also didn't bring him on, and so
Right, right. So let's go to the
Yeah,
tamper.
let me just
Okay,
make one point,
sure.
Matt, and see that, and I know we're going to talk about this a little bit at the end, but I think that goes towards if they're going to retry the case, how both the prosecution and the defense will probably look to approach it, which is different than the first trial.
Yeah, yeah,
well,
yeah.
okay. So let's move on to this tampering stuff, which what you've just said is probably the biggest issue. The state called former clerk of court Hill's statements foolish and fleeting in their filing, which to me indicated a minimal effect of those comments. What maybe a minimal effect these comments had on the verdict. Maybe the jurors they're so minimal and fleeting that they didn't care. Does it matter if the clerk's statements were only foolish and fleeting?
No, the fact that you have someone of such a power position in the court, making statements to the juror, basically indicating guilt, and driving him in that way, is enough in and of itself. Even if the statements were foolish and fleeting, it seems to me that the fact that it happened is enough for the court to strongly consider giving him a new trial because his first trial wasn't fair
It
under
was
Robert.
we brought it, and I don't know how it is in Pennsylvania, but we interviewed a New Jersey attorney few weeks ago about this, and he says, like, for instance, in New Jersey, you can't, you're not even supposed to be in the same elevator with a juror. Like, there's has to be completely no look of any impropriety. So when you take a clerk of court, as you just said, that's a big difference saying something fleeting than if it's somebody in the gallery screams something out, or they're on the way to court, there's people outside, right? So in the Karen Reed trial, they did a lot to make sure that the jurors didn't see what was going on outside the courthouse. So one of the main things what you mentioned is important to point out is the clerk of court saying this is way different than a fleeting comment from anybody else.
Exactly.
Okay.
Exactly. And the fact that she's in such a power position, being a clerk of the court, she's the one, for example, that was involved when they first were sworn in. She was the one that read the jury verdict when it came out. And she was there at all stages, basically running the show from their point of view. That's a very powerful position, and that in and of itself, creates the harm to the trial.
All right.
So
There's a structural error question. Did
oh
you
yeah,
take
yeah,
that?
no, go for that.
The brief says there was a structural error in the trial relating to the tampering and that the trial court improperly examined jurors about the deliberations in the case. All right. So what exactly does that mean? And what is the argument being made there in in your take?
Well, the argument, I guess, is suggesting and I think they're talking about the Judge Newman initially interviewing the jurors, not the hearing before Judge Toal. I think what they're suggesting is that some of that was done in camera, some of that was done in an odd way, and it should have been more transparent, and there should have been more view for the defense attorneys and others when that happened. Um, I think that's probably a fairly decent argument, but I'm not sure that in and of itself would be enough to give him a new trial. I think what it really still comes down to is the clerk of court and her direct contact with the jurors.
So the brief also addresses the credibility of Juror Z, and this was, during the evidentiary hearing conducted by Justice Toal. The filing
Right.
says the court awkwardly found that the only juror who gave an answer favorable to the defense not credible when reporting her own mental process, even though she was alleged to have
Not alleged.
not alleged to have any bias in favor of Murdaugh. She voted to convict him. So can Justice Toal's assessment of Juror Z's credibility be argued?
Well, I mean, reading and listening to it, I think I listened to it when it was going on live. That I mean, Juror Z wasn't exactly um, clear in all instances, seemed to be a little bit awkward in the way she presented herself and the way it took place. With that said, it was crystal clear that she discussed tampering by the clerk of court with the jurors. And I think that in and of itself should have resulted in in the court strongly considering a new trial at that particular moment. I think that Justice Toal, I know, has a pristine and great reputation, was overly persuaded by what she considered to be the overwhelming evidence of guilt, and therefore had simply concluded that this juror was not credible. Um, I'm not sure that's correct, with all due deference to Justice Toal. And I think that the right determination should have been at that time that once that came out, that was prejudicial, and that the burden completely shifted to the prosecution. And I don't think they could overcome that burden.
You're saying so when Gen Z said there was jury tampering, that even though she said voted for guilt,
Well, and she
yeah,
waffled in her responses a little bit.
yeah, well, yeah, you and I both felt like if it was like it was kind of confusing the wording
Right.
exactly, and I think, and I'm not a justice like Justice Toll, but there could have been a follow-up question to kind of clarify what she meant as opposed to saying she's not credible.
Yeah,
That's
and
I
I
saw.
and I think obviously the defense, Murdaugh's lawyers realized that, because wasn't she the juror they tried to put an affidavit into after the lunch hour?
Well, her attorney sent a note to Justice Toll,
Okay.
yes,
To
saying that wanted to
clarify her
clarify her
testimony.
Yeah,
statements.
Claire.
Yes.
Yeah,
Right.
exactly. So I mean, everybody sort of realized that, but I mean, the one thing that was clear was that she said that there was jury tampering.
Well, so, one thing though, uh, if you could kind of explain, Justice Toll is not allowed to inquire about what happened during jury deliberations. And why is that?
Well, because that's supposed to be within the confines of the jury. That's the way our system works. Only thing she's supposed to inquire about is whether or not some outside influence tried to tamper with the jury.
So she can't say, "Hey, tell us, what was said in the confines of the jury room."
That's correct.
She can't say any of that.
Even if it I mean, I know they can't get into the arguments, but if it was referenced, if somebody in the jury room said, well, Becky said to look at their blah, 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 would that be
That certainly is a lot closer to the line
okay,
if the
closer,
question
but
was
still
asked
not
that
there?
way.
Okay.
Well, maybe, but it's something I'd have to think more about. But I think that she was really inquiring over the global or the large deliberation that was going on within the jury room.
Right.
And that's what the issue was there structurally, I think.
And we've said a couple of times, it does seem that Jersey felt pressured by other jurors, which is okay. But it could be that she felt pressured, but she was also told things by the clerk, which influenced her.
Yeah, you got to remember that, Jersey participated in a lengthy trial. They call her in for this hearing. They put basically everybody in the same room. If I recollect right, people were watching on their phones, the actual
Yeah.
Yeah, that
testimony
was
that was
that was
going on.
Yeah.
crazy.
The other
Yeah,
jurors
yeah,
had their phones, were watching Jersey
yeah.
testify. Yeah.
And so there she is after watching this trial in which lawyers the original trial, were aggressive and forceful in their presentations like they should be. She has to now get up there on the stand and testify with this cadre of lawyers who are very good at their job, are going to question her. She's got Justice Toll, who's very impressive also, TV cameras in the room, a whole audience of people sitting there. You could see why people could get very nervous and flustered by what was going on a little bit. And I think that that's sort of the environment that she was operating in. And I could understand why she came across as a little confusing and a little awkward during her testimony.
But you're saying even if, it doesn't even matter whether, in your opinion, it doesn't even matter if Hill's statements influenced Jersey in any way. It's just the fact that Hill made those statements in any case because of her position as a clerk of court is enough.
Well, the fact that she heard that stuff and that was there, the idea is that one way or another, that's going to infect the entire jury.
Right.
And that therefore it's tough, as I said, once that happens to put the genie back in the bottle. How are you going to recreate the situation before that? How do you really know at that particular point what influence and didn't influence? And
We go
that's
through
what
life being influenced by things, commercials, etc. We would say, "Oh, it didn't affect me, but I still bought that kind of car or that kind of thing or whatever."
exactly, 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 exactly. And so I think that that was the whole idea behind the rule.
Okay, so let's move on to the financial crimes. The appellant calls the financial crimes in their brief irrelevant, and it says that they were used to distract from the absence of proof of Alec Murdaugh's guilt. In the state's brief, they were talking what this whole storm was brewing.
Right. All this was coming to a head, and their theory on motive, which of course you don't have to have, was that it was all going to be found out that Alec was stealing this money and that he was actually broke, and it was going to come out, and so he did these murders to distract and give him some time to set it straight because no one was going to attack him when he has a dead wife and a dead son.
So the appellant says that these financial crimes are not relevant. Uh, can you argue the relevancy of the financial crimes at this point? Is that a valid argument?
Well, yeah, it's a valid argument to make. Will it succeed? I doubt it. In these cases, just a couple of quick points. One, that in order to prove guilt, you don't have to prove a motive. You just got to prove they did it. So, for example, the murderers out in Idaho, he ultimately confessed, and nobody ever knows the reason for it. It's simple. So, in other words, you can get a conviction based upon the weight of the evidence, eyewitnesses, the fact people saw him do it, other ways, and you really don't have to show a motive. You don't have to show a motive in these type of cases. So, but I think the government realizes that when you're dealing in these type of situations where you don't have weapons, where you have a family situation to the outside world that probably look pretty normal.
No DNA.
Yeah, you don't have any DNA. You don't have any blood spatter on the guy. You don't have a lot of other stuff there that they got to try to show a motive as to why he did it. And therefore, so the jury can say, yeah, it is. And I think that probably, well, I don't think probably, I know that the prosecution did a pretty good job, I think, in their brief and on appeal here, trying to show what the motive was and why he did it. Do I necessarily agree with it? I don't know. But I mean, it does sound like it's reasonable, it's rational, and it does show reasons why he could possibly do
I
it.
mean, I bought into the motive a little bit with that with in this after reading the state's brief. It made sense to me for the first
Yeah.
time. So, I mean, I think it is reasonable that some may find that a compelling motive and some might not. Again, like what you said, it's not necessary to present a motive. I mean, we do have this smoking gun video of placing him at the scene shortly before the time of the murders.
Right.
But, we, like you said, there wasn't a whole lot of other evidence beyond that.
Also, you got to convince 12 people that somebody would shoot his son, who they just showed laughing and giggling and all these other
In a
videos.
very brutal manner.
And everybody read that. I think that they felt they had to have, like, why would he kill his son? I mean, that's outrageous. And wife. But the son, there was video of the son presented of like, hey, we're goofing around, we're doing this. And like 2 hours later, he shoots him in the head. So I'm sure they thought they had to do that. And I also, who's getting who? I think they thought if we can figure out a way to get some of this, he's a bad dude into this, it's not going to hurt so much either. You know,
Yeah,
um,
I think one other thing to just talk about for 30 seconds is the fact that the judge let him go on, as Seaton said, for over a week. And that seemed to be overkill in allowing them to get into that. The judge should have, in my humble view, put some limits on the amount of stuff and how they were going to get into it in certain ways.
Well, he didn't even say that at the beginning of the trial when they were going back and forth on what to be in. He said, I'll keep it very limited, but it wasn't all that limited, I guess. But
No,
that he had stated that at the beginning of the trial.
right.
Well, he
Um,
was going to take it as it comes,
yeah,
and it wasn't until this whole opening of the door situation that he allowed the floodgates of the financial information to come in.
which is the character evidence, which we have talked about, but since it's back in this, the defense is saying that was unfairly prejudicial, which denied him his due process. And the character evidence is to go back on that. The door, they say, was opened because of Jim Griffin.
His questioning of a witness where he was asking about the nature of the relationship between Alec and his other family members.
And the defense said, or the prosecution says, hey, it's open now. So when these people came up for financial crimes, or the financial crimes thing, he also was adding questions like, tell me about Alec Murdaugh and the kind of people he ripped off and that sort of thing.
Yeah,
So is
I
there
thought,
anything there?
candidly, I thought it was a little close to the line in the terms of the judge finding that that was enough to open the door. But I
Okay.
guess he could, and the judge, and I think if that was the only issue there, the Supreme Court would say it was okay. But I thought it was pretty close to the line in deciding that that one question, that one area, soliciting that one statement was enough to open it all up.
Um,
Okay, so you were mentioning just a few minutes ago about the extent that the financial crime information was allowed in. So that is an argument that they're making that, hey, this was so much, uh, and that was unduly prejudicial to our client because you allowed in a week's worth of testimony about this. Um, what do you think about that argument?
Yeah, I mean, maybe a Supreme Court justice may latch on to that. I think probably not. I think probably the court will find that if that was the only issue going up on appeal, they'd find that was harmless error.
how
And
about
that was within the judge's discretion to limit or
Yes,
allow or limit however much testimony regarding the financial crimes he saw fit.
exactly.
okay? So the brief mentions and argues that Murdoch's Miranda rights were violated. What is that about?
Well, I think what that goes to, if my recollection's correct, is that it goes to the Paul's video. And I think a number of times after that video came out and his initial statement to the police, the prosecution kept on saying he never came forward thereafter and explained what was going on there, or gave us any reason for it, or why he said something different initially. Um, and the argument is that, well, under Miranda, he has an absolute right to keep silent. He doesn't have to come forward and incriminate himself and provide information like that. Um, I'm not sure that's going to be all that compelling of an argument for him, because you did have him initially with counsel sitting down, I think, in the police car or van, talking to them
With
and
attorneys?
yeah, with attorney answering those questions, and then I found out what he said was untrue.
And
Uh,
he himself
yeah,
is an attorney. Does that matter at all?
not really. It's just the fact that he had another attorney is the thing that helped him out. With the, that's what helps the government's case out on that. So I think that that's really what sort of opened that up. And I understand them maybe overkilling that a little bit, but I think that was probably, as you said, in the judge's discretion. And if it was error, it was harmless error.
Well, so they're throwing I guess everything at the wall in this brief because when the Supreme Court agreed to hear, they said, "Hey, we need to hear every argument you have, not just this jury tampering stuff." So I guess they're probably throwing everything at the wall at this point. But they talk a little bit about some of the evidence that was presented. We have the cell phone guy throwing the
Yeah,
phone
yeah.
out.
He was to show that if you throw a phone out the window, which is like it's Maggie's phone out, the way it would tumble and the way it would register on the phone. But the guy's like just some, I don't know.
They call it unscientific,
Yeah,
and
and it was when at the time we are all like, what is
everyone
happening
in the
here?
courtroom, including the jury, could probably assess what they thought the credibility of this particular witness giving this experiment that he did over the weekend
Yeah, the
was.
technical legal term for that is junk science.
Yeah.
Which is easily as the defense to be like, okay, dude, do you got any, background in this? You threw the phone 10 times and you came up with this. There's ways to just discredit him right then and there pretty easily.
Well, in fact, the defense could almost use that to their advantage by saying, look at how desperate the government is. They
Ah,
brought in this clown who gets up there and does some goofy experiment, which anybody knows is junk science, and claims that he's trying to establish some fact that convict our client. You know,
right,
yeah,
right.
so you could use it in an effective way like that.
Well, and they had kind of addressed some of these other issues. So, are these just kind of throwing everything at the wall, or do you think anything that you saw there had real merit?
The stuff that I thought had, any sort of merit was the way they proceeded with the grand jury. And by basically getting him indicted on information that was incorrect. And now a lot of information came out after the fact that would have justified an indictment, and that's probably what they're going to find. As I said at the beginning, I think a lot of this is defense lawyers are trying to do their job for their client. They don't want to be criticized after the fact for ineffective counsel, so they're raising everything they can with the hope and view that someone will grasp onto it. I've argued all sorts of cases on appeal around the country. And occasionally you will get a justice who will seize upon one of these issues. Sometimes, I don't want to say to my surprise, because I was fortunate, got fortunate on that side, if someone agree. But someone will seize upon that issue, and that'll be the issue that'll result in a reversal.
Okay, so when they're trying to decide if it's appeal,
Yeah.
they don't do like, okay, well that's sort of correct and that's sort of correct and that's sort of correct. There's a bunch of sort of corrects, so we'll say appeal works. It is they take an issue, and that one is the one that the appeal is put on. It's not like you have a
Or,
bunch of little appeals.
or the little things kind of all add
Yeah,
up
how
that
does
can
that
be
work?
cumulative.
Well, two things. One, if I have a civil case, for example, there's a big merger and it goes sour and the parties are suing and there's a trial and someone loses and they take an appeal, then you got to be a little bit more discreet upon what issues you pick and go up and appeal. In a criminal case, however, it's different because what you really want to do is you really want to be able to preserve all sorts of objections, hoping that something will resonate with the judge. And so you're usually talking about some sort of being deprived of some constitutional right, such as due process, the right to a fair trial, and other things like that. That therefore you want to raise all these issues, hoping it'll strike a chord with one of the judges or justices who will decide that, yeah, this is not right. We need to correct this.
Okay. Let's see. Is there anything else in the brief? Well, one of the things is we want to talk about um, this last guest we had on. One of the things that they said was this could go back to the Remmer hearing. There could be, in fact,
Be remanded, I think.
remanded. So basically, as I understood it, it would be like he doesn't necessarily get a trial, but the Supreme Court says you've got to dig deeper into what happened in that hearing there and what really happened with the jurors and the tampering. Am I getting that right? What his theory was?
Yeah, that was Albert Wunsick, I think, who was
Yeah.
in one of your a couple of weeks ago, who was I thought was very good. I know he's on court TV all the time and has a great reputation. I respectfully disagree with him on that. I think um, that they effectively had a Remy hearing before Justice Toal. That was the purpose of it. And I think the issues are rather straightforward and clear, and that is that if there was jury tampering, as as I said a number of times, it doesn't go to his guilt or innocence, it goes to the fairness of the trial. And that therefore, if that took place, he should, under Remmer, get a new trial.
Okay.
Well, okay, so maybe some of what, to your point that you said earlier, if he is granted a new trial, uh, how would this new trial look different from what the first trial looked like? And if you were his attorney, what would be your strategy?
Well, yeah, let's talk about what would take place. I would first of all want to file some motions, what they call motions in limine, which are trying to limit the evidence that the government can present. So some of these issues that were raised on appeal, I would try to see if I could get the new trial judge to limit what the government can put in and not put in, first of all, on some of the good items that you guys raised. The second thing that I would do if I was the defense is that at the trial, I would be very careful about opening the door to any financial crime information coming in. Keep it a straightforward case with it. The biggest issue he's going to have is that his conversation with the police and the video that came out from Paul's phone sometime thereafter that took place right around the time he was killed. That's the biggest problem he's got to deal with. But with that said, I would concentrate. I wouldn't put Alex back on the stand.
Yeah.
Yeah, I would concentrate on basically trying to create enough doubt in the juror's mind that he was not guilty. I would use the fact they don't have a weapon, the fact that they don't have any blood splatter, they don't have any of their blood on him in any way. They didn't find anything in the house. I would concentrate on how the government didn't follow up the investigation with regard to the tire marks and other things like that. I would use the cell phone data to show that he in fact went to the mom's house and there's no indication that he had any digital data that related to either Paul or his wife after or during when they were killed. And I would try to present the case in that way with the view that I could create enough doubt in the jury's mind that they would have to come to the conclusion that they were not guilty. If I was the prosecution on the other side, I would have to concentrate heavily, if I'm right, that that's the way Alex is going to proceed. I'd have to proceed. Have to proceed with a view of really concentrating on that video of Paul right before he was murdered and Alex's contrary statements to that. I would argue, in effect, that's a smoking gun. He denied it, and then we found out sometime later when this was able to be restored that he was there, and at that particular moment or moments thereafter, they were killed. You got to believe he's the only one that did it. Nothing else has come forward to show anything else. And that's
What
why I proceed on both sides.
Would
what are,
you?
go ahead.
Oh, go ahead.
Well, I was going to ask just a kind of a general type question on this. Like, they say that the prosecution, SLED, did not go after any other possible suspects. How, what are the rules on presenting other suspects? Can they say, for instance, I'll just make
Eddie,
something up.
cousin Eddie.
Right. Or
No,
Alec Murdaugh was deep into these drug people. What do you have to support when you throw out, like, say, a random alternate murderer?
Well, it all depends where you are in the case and what evidence you get in. You can always, particularly in your closing, try to raise doubt in the jury's mind. Listen, they didn't find, they didn't find, as I said, a weapon, any blood splatter or anything on him in any way, and that there's no evidence out there suggesting that there was a bad relationship between any of them. There doesn't seem to be any particular reason why he did it, and they because at this point the government is a little stripped that they present it the right way and getting into all this financial crime and other motive stuff that they're able to establish, that they can try to create a lot of issues and stuff on that and say, you haven't heard the government in any way present any evidence that they went after anybody else or looked at anybody else.
So you don't have to be specific who they should have got after. You just say
Yeah.
they didn't look.
Yeah,
so
yeah, they didn't look. They didn't go after anybody. They haven't presented any evidence or anything about their investigation. Why? Because their investigation was sloppy. They didn't follow up the car tracks. They didn't follow up other information there. They didn't follow up any information, about any other potential reasons why people may want to kill them.
but you can't say, "Hey, look, the local kindergarten teacher at Hampton County Elementary School, whatever, I don't know what the name of the elementary school is, she doesn't have an alibi for that night."
Just a random person.
Random person,
Yeah.
you
No,
you
no,
can't exclude the universe.
Yeah.
no, yeah, no. But you can point out that the investigation was such that they didn't really look at anybody else or go after anybody else because they're going to put police officers on the stand, and I'm sure if you say, did you look at any other suspects? What are they going to say? Uh,
We, well, speaking of other police officers, the lead investigator, David Owens, Yeah, he was involved in this other Sarah Colucci case where got thrown out, for the time being because he didn't provide the defense with potentially exculpatory information.
Right.
So,
And he was also the one who did
what
the grand jury.
right, and he's the one who testified in front of the grand jury. So obviously there's some credibility issues with David Owen. Is it Owen or Owens?
No S, I don't think. Just
No
Owen.
S, just Owen. Is that something that the uh, defense could present in a new trial, the credibility issues with this investigator?
Absolutely. Absolutely. They're going to say that the lead investigator for the government in this particular case has all sorts of issues and has been found to have basically lied and tainted evidence. And we know in this case he's done that also. And if he gets on the stand, they can then go after him, impeach him, and present all that out and say to the jury, you can't believe anything the government says here.
Would
Right.
would the government try not to bring him on and just bring in the evidence through other witnesses?
I think they're going to try that. I
Yeah.
mean, the defense could subpoena him to trial if they wanted to. Did Owen testify in the first trial, right?
He did
Yeah.
testify in the first trial,
Yeah.
yes.
Yeah.
Yeah.
So I think that probably the government may want to try to avoid him, but the defense could call him if they want. I said the biggest problem the defense is going to have is trying to explain the little tight couple minutes between that video and their death and where was Alex and what did he do. That's
Right.
going to be the toughest. I mean, I guess they're going to try to say that, well, he left, went back to his house, and whoever was there must have been watching and killed him then.
Yeah, that's probably what to go with. That it's a big
Yeah.
property, lots of places to hide.
A lot of
Da,
if,
da, da.
because
Yeah.
right now we don't, we don't know if he's going to get a new trial. Do you have any prediction about what the Supreme Court may rule and which arguments they would want to hear?
I think the Supreme Court is going to spend most of its time dealing with the tampering issue. And I think that the Chief Justice, is trying to build back up, as I think we talked to in the prior episode, new confidence in the court. And I think we talked about it last year, new confidence in the court when he came in last summer as the Chief Justice.
Yeah,
And I think
Kittredge, he said his whole platform was transparency.
yeah. So I think it's going to be tough for him not to decide to give him a new trial. I mean, that doesn't mean he's going to get away with it.
No,
It
no, no, no.
just means he's going to have another trial. And the evidence, a lot of the evidence is still pretty overwhelming that he did it or was at least involved in it.
Well, that's what our last guest said. Obviously, maybe the state should say, hey, look, this is a slam dunk. We have this overwhelming amount of evidence, and let us do it again, and he's going to be found guilty right again. The verdict was right the first time. If there was this tampering, let's do it again.
Yeah,
Yeah, but you get some politics involved too.
of course.
Yeah, there
I
are.
mean,
Yeah,
Alan
your
Wilson
attorney.
is the lead AG. He's the Attorney General of South Carolina running for governor. And
Exactly.
this is a big, harsh hit to him if Alec Murdaugh gets a new trial.
Exactly.
But if
Exactly.
it's
So,
but if it's if he gets a new trial based on the tampering allegations, that's on the clerk, not on him.
Yeah, well, it's not. Of course, it's not. But that doesn't mean that people will see it that way, right?
yeah, people are going to look at wins and losses.
Right.
And they're going to say, you didn't really win this one. You lost it. Now I got to go back and try again.
Well,
That's why Alan Wilson.
Colucci
Yeah,
was a loss. Colucci was a loss, and it wasn't anything really that the state did in that case. It was just that
David
the,
Allen.
the investigators didn't have turn over what they needed to turn over to the defense.
Well, that's why also Alan Wilson can't just go, hey, I mean, to make sure everybody has a fair trial, no matter who they are. And if there was a mistake, that's fine because we can retry this and he can't really do a principle thing like that or he's
Yeah,
going to get cooked.
yeah. And remember, Owen in that case was the state, and the attorney general are the lawyers for the state.
Well, that's true. Yes.
And every time I've had a case, if you're going to handle a case the right way, you almost have to identify with your client and take it a little personal. So win, lose, or draw, whatever way it goes, you're living it with your client. And so there's some of that with the Attorney General's office and Waters and Wilson and all that. At the same time, Wilson has other political goals and stuff in mind. I think as you said, he's running for governor. I don't know if she is yet, but there's rumors that Nancy Mace
She
maybe
is.
She's announced, yeah, she
he's
is.
announced. Okay, so I mean, he's got some huge competition that he's going to be facing in that battle. So something like this is not going to be good for him.
No, because Nancy Mace is attacking already his soft on crime kind of thing.
Yeah, and the whole
So
Spivey situation, I don't know if you've listened to the episode. That's case has
stand your
made a
ground.
lot of news in our state with the stand your ground laws. Oh, you came on and
Yeah,
talked to us about that.
yes.
Yeah. I did. Yeah.
So a lot
Yeah,
of high profile cases over the last couple of
yeah,
years.
and the suggestion will be by her, I'm sure, that if this case is reversed and sent back, that they didn't do it the right way the first time.
Right,
And
right,
and
right.
that's why it went back. They screwed it all up the way they handled it, the way they did it. They should have done so. Now, you're right. The fact that the clerk of the court, sort of was a renegade out there, doing something they really couldn't control. But it's not going to be viewed that way, as you said, Matt. It's going to be viewed that he lost the case.
Yeah. There we go. Any other ones for
Oh no, we did have a really nice review. I don't have it right in front of me, but someone on Apple said Seaton's dad rocks. I thought you would like
ah.
that one.
Oh, I do like that one.
Professor Matt, we appreciate it. Thank you very much. We'll talk again soon.
Thank you, and go birds.
Yeah, definitely go birds.
Birds.